Faria. Mr. Faria,
Yes.
you speak Portuguese?
Sim.
All right. Mr. Interpreter, we're going to swear you in to interpret from Portuguese to English.
All right, ma'am. All right, Your Honor.
Do you solemnly swear to translate from Portuguese to English, English to Portuguese, to the best of your ability, so help you God?
Yes, Your Honor.
All right. Mr. Faria, in your case, I find probable cause for count 1 and count 2.
Então, Senhor Faria,
Sim.
em seu caso, eu estou achando o caso provável para acusação 1A e 2.
Sim.
Count 1, DUI, bond is set at $500. Count 2, no valid driver's license, bond is set at $500.
Então, a primeira acusação de dirigir sob influência tem uma fiança de $500. Segunda acusação, dirigir sem carteira de motorista, uma fiança de $500.
Sim.
You are ordered to not drive without a valid driver's license.
Mandamos para você não dirigir sem carteira de motorista válido.
Sim.
And you are ordered to consume and possess no alcoholic beverages as a condition of your bond.
E mandamos que você não tome nem tenha em seu posse nenhuma bebida alcoólica como parte da sua fiança.
And I am ordering you to submit to random urinalysis or random alcohol testing.
E eu mando para você fazer exames aleatórios de álcool na sua urina.
The random testing must be conducted by the pretrial release program.
Esses testes aleatórios serão feitos por nosso programa de liberdade antes de prova.
I am also appointing a public defender to represent you.
Eu também estou designando defensor público para te representar.
Sim.
Thank you, sir.
Obrigado, senhor.
Thank you, Mr. Interpreter.
You're welcome, Your Honor. Have
You're
a good day.
excused. You too.
Thank you.
Michael Smith.
His mental health, Your Honor.
Your Honor, could we reset for tomorrow? I didn't see any competency, and he has an offer to resolve his case.
All right, per the request of the public defender, the case will be reset for 24 hours. We'll recall him tomorrow. Jacob Ross Mound.
Mental health, Your Honor.
Your Honor, I would also ask that it be reset. He didn't have any competency issues, and there was an offer to resolve.
All right, we'll reset that also for tomorrow. George Savage Dovo.
Mental health, Your Honor.
And I will waive, Your Honor.
All right, his presence is waived. I do find probable cause for petty theft, and I am setting a bond of $250, ordering no contact and no return. And Ms. Public Defender, some information that PTR provided to me, I don't know if they provided to you, was the defendant may have autism.
Yes, Your Honor.
And they were attempting to contact his mother to, he doesn't qualify for PTR, but he might possibly qualify if they can get in contact with his mother.
So could we do pretrial release or?
If he qualifies? Yes, the court will do pretrial release if the defendant qualifies or a $250 bond. Conditions remain the same whether it's PTR or bond. Thank you. Keith McDarrell. Sir, and the court finds probable cause in your case for trespass in an occupied structure or a conveyance.
Fake mitochondria.
Your Honor, there are competency issues in multiple cases, so I'd ask that you take no action on the out on bond.
All right, the court finds probable cause and sets a bond of $250. Further, the court is ordering no return and no contact. Court will take no action on the out on bond case. Public defenders appointed. Eliezer Torres. Eliezer Torres. Sir, the court finds probable cause for the offense of misuse of a 911 and orders a bond of $500. Orders as a condition of bond that you not contact 911 unless it's a verifiable emergency. The public defender is appointed. Thank you.
Did you say the bond, Your Honor?
$500.
Thank you.
Seth Minak.
Mental health, Your Honor.
Defense will waive, Your Honor.
Defense is waiving his presence. The court finds probable cause for petty theft with 2 prior convictions. Bond stays at $1,000. No contact, no return as a condition of bond. Want to go to the arraignments now. Robert Arthur Angel,
He's in a restricted unit, Your Honor.
And
public defender previously appointed.
defense will waive and enter a plea of not guilty, Your Honor.
Okay, plea of not guilty entered. Set this for pretrial conference.
Division 63, pretrial conference is November the 17th at 1 p.m., courtroom 10B.
Jaron Christopher Sullivan,
He's in a restricted unit, Your Honor.
public defender previously appointed.
I will enter a plea of not guilty and waive, Your Honor.
All right, we'll set that for pretrial.
Case to be heard, Division 82, pretrial conference is November the 9th at 1:30, courtroom 9B.
Benjamin Gray Carroll,
In a restricted unit, Your Honor.
public defender previously appointed.
We will waive and enter a plea of not guilty, Your Honor.
Okay, we'll set this for pretrial conference.
Case to be heard, Division 84, pretrial conference is November the 9th at 8:45, courtroom 4B.
Thank you. Joshua Connolly.
He's at restricted podium, Your Honor.
Mr. Connolly, in your case, you're charged with count 1, assault on a law enforcement officer, count 2, resisting an officer without violence, count 3, possession of paraphernalia, count 4, trespass on property other than a structure or a conveyance. Public defender has been appointed.
We'll enter a plea of not guilty, Your Honor.
You have not guilty entered. Let's set for pretrial.
Case to be heard, Division 84, pretrial conference is November the 9th at 8:45, courtroom 4B.
Thank you. Marcus Demetrius Demps,
He was ROR, Your Honor.
ROR per the jail staff. Maria Eduarda Fidelis Lima,
She's in a restricted unit, Your Honor.
public defender was previously appointed.
We will waive and enter a plea of not guilty, Your Honor.
All right, plea of not guilty entered.
Case to be heard, Division 50, virtual pretrial conference is November the 18th at 9 a.m.
Nike Henderson,
He's in a restricted unit, Your Honor.
public defender previously appointed.
We'll waive and enter a plea of not guilty, Your Honor.
All right, plea of not guilty entered.
Case to be heard, Division 50, virtual pretrial conference is November the 18th at 9 a.m.
Thank you. Vincent Keevan Johnson,
He's mental health, Your Honor.
public defender previously appointed.
Defense will waive and enter a plea of not guilty.
Plea of not guilty entered.
Case to be heard, Division 63, pretrial conference is November the 17th at 1 p.m.
Thank you.
10B.
Ray Anthony Lamar,
He's mental health, Your Honor.
Defense will waive and enter a plea of not guilty, Your Honor.
all right, we'll set that for pretrial.
Case to be heard, Division 85, pretrial conference is October the 31st at 9 a.m., courtroom 4A.
Adelbert LaQuinta Noshi Parsons,
He's restricted, Your Honor.
Defense will waive and enter a plea of not guilty, Your Honor.
this one has regional counsel.
Oh, okay. I still see.
Did regional counsel file a waiver? Okay. Hmm. Um, Did you all send a notice to regional council for the arraignment today?
Was, yeah, if you, enter a plea, we would notify the region.
But they weren't notified for today? Oh, you don't? All right, well, I'm gonna enter a plea of not guilty and set it for pretrial.
Division 84, pretrial conference is November the 9th at 1:30, courtroom 4D.
And the, please, Madam Clerk, notify Regional Counsel Dean Mosley. Okay, thank you. Cedric Ornato Perry.
He's at the podium, Your Honor.
Okay, Mr. Perry. Sir, today's your arraignment. You were charged with trespass in a structure. The public defender represents you. What does he wish to do on this case?
We will enter a plea of not guilty, Your Honor.
All right, plea of not guilty, set for pretrial.
Case to be heard in Division 83, pretrial conference is October 31st at 8:30, courtroom 6C.
Thank you. Maureen Samuel.
She's temporarily released, Your Honor.
All right. She's released already?
Yes, ma'am.
Okay. We're set for pretrial. Public defender previously appointed.
Case to be heard in Division 61, pretrial conference is November the 21st at 9 a.m., courtroom 7C.
Jermaine Terrell Summers.
He's at the podium.
All right, Mr. Summers, you're here for your arraignment for a charge of violation of pretrial release conditions on a domestic violence case. Public defender is appointed.
Defense will enter a plea of not guilty, Your Honor.
You have not guilty entered, set for pretrial.
Case to be heard in Division 50, virtual pretrial conference is November the 18th at 9 a.m.
Bruce Anthony Taylor.
He's in a restricted unit, Your Honor.
Public defender was previously appointed and has filed a written plea of not guilty and a waiver, so this will be set for pretrial. Public defender. Oh, sorry, Taylor, yeah, sorry.
Division 63, pretrial conference is November the 17th at 1 p.m., courtroom 9B.
John Frederick Welter. Public defender appointed.
Yes, Your Honor. There was an offer to resolve the disorderly conduct in 2022 MO 97480 of an adjudication of guilt, credit, time served, and court costs. And Mr. Welter would like to accept and enter a plea of no contest.
Has he read a plea form?
Yes, I provided one earlier.
Did he read it?
Went over. But she's asking if you read the plea form.
Yes, ma'am.
All right, may I see the plea form?
Yeah.
Mr. Welter, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And you say that you read this plea form, sir, before you signed it?
I did.
All right, do you understand that by entering a plea of no contest, you're giving up the rights on the plea form? You understand you're giving up the rights on this plea form?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medicine today?
No, ma'am.
Do you understand that conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, there's a sufficient factual basis. You're alert, you're intelligent, you're adjudicated guilty, you're sentenced to serve 47 days in jail with credit for 47 days time served. And you must pay mandatory court costs within 365 days of your release. I am releasing you as to this charge. Do you have any questions? Any
No, ma'am.
questions, sir? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
Thank you.
No, the cases that you came in.
You may exit, sir. Anthony Williams,
Restricted, Your Honor.
public defender was previously appointed.
Defense will waive and enter a plea of not guilty.
All right, plea of not guilty entered, set for pretrial.
Case be heard in Division 62, pretrial conference is December the 15th.
Nearest Salvador or Salvador Neres? All right, Mr. Neres, sir, you're here for an arraignment on a charge of driving while your license was suspended or revoked.
Yes, ma'am.
The public defender was appointed, I'm not sure on this case.
Yes, Your Honor.
All right, yes, ma'am.
It was set for a plea in 2020
Mm-hmm.
CT 242080. The state's making an offer of an adjudication of guilt, credit time served, and court costs. Mr. Nares would like to accept and enter a plea of no contest.
I don't have a factual basis for the charge of driving on a suspended license, but I do have a factual basis for no valid driver's license.
Yes, Your Honor, defense will stipulate.
All right.
That's what the attorney said.
May I see the plea form?
Yeah, that's right. Did you have them set for all of them?
Mr. Salvador, is this your signature here at the bottom of this plea form?
Yes, Your Honor.
Did you read this plea form in its entirety before you signed it?
Your Honor?
Yes, ma'am.
I apologize. This is not either one of our cases, and unfortunately, we didn't have a lot of notice, but it does appear as though it's going to be a global plea.
Okay.
If I could give defense just a moment to look over, possibly it could just be this one, but there is an offer of a global plea, Your Honor.
Okay, how many cases are involved?
It would be 3.
All right, well, what are the other 2 charges?
The other case, they are both traffic cases, Your Honor.
Okay,
I can give you the case numbers, but I will.
you don't know I need the charges as well.
One moment. Probably. 20 CT 2422 is leaving the scene of a crash with property damage.
I don't have a factual basis for that.
Defense is willing to stipulate, Your Honor.
Okay. Any other one?
I apologize, Your Honor. The number that is listed on the docket does not appear to be correct, so I'm just trying to double check that.
Okay.
The correct number, Your Honor, would be 20 CT 5207. That is for a no valid driver's license.
I do have a factual basis for that because I reviewed his driving record from 2020. So,
What about this? What does that mean? 20 ACS?
Alternative community service.
Oh. What about the restitution you're?
I feel everything,
Yeah.
every last bit of that.
This is ridiculous.
The evidence are here goes to, of course.
Okay.
Oh, it looks as though it's $500.
For what, the cost of investigation?
No, the restitution. There is going to be no cost of investigation.
Can you reserve on that?
I also asked for the details and didn't get any.
And does the global plea, result in his release
Yes, Your Honor.
on all cases? Okay.
There isn't, let me do the last one, but if it's highway patrol, it's never a cost of investigation. Madam Clerk, do you have the numbers or do you need them? Thank you.
At the time served, yes, 78 days.
That's okay. I'll just do a court cost. Wait a minute, are you all talking about restitution?
Yes, Your Honor.
So restitution, I don't order restitution on a leaving the scene case. It's illegal. It's illegal. I don't order it. There's a case law that does not allow me to order it. I mean, he could agree to it, but I'm not gonna let him agree to it under the duress of getting out of jail. I'll ROR him and he can come back and no judge is gonna make him pay restitution on a leaving the scene case. It's not directly related to the charge.
Is that okay?
This, I would, as it's not mine, and those are the terms that were laid out, I would prefer then that this go back to the trial division. But if the judge wants to release some ROR without resolving the case, then yeah, that's fine.
Your Honor, so could we do an ROR, because
Yes, ma'am.
the state's not?
He's been in jail 78 days on that case, which is 78 days more than most people. But it's probably because of his failure to appear. So of course, yes, I will do the ROR. If he wants to go ahead on and plead to the no valid and the DWLS, that's fine. I'll sentence him on both of those at this time.
Yep, because we're not doing this.
Okay, sir, as to the charges of driving on a suspended license and no valid driver's license, is this your signature here at the bottom of these plea forms?
Yes, it is.
Did you read these documents before you sign them?
Yes, ma'am.
And do you understand that by entering your plea of no contest, you're giving up the rights on the documents?
Yes, Your Honor.
Are you under the influence of any alcohol or drugs or medicine at this time?
No, Your Honor.
Do you understand a conviction on this case will subject you, or these cases will subject you to deportation if you're not a U.S. citizen?
Yes, I do.
All right, sir, there is a sufficient factual basis as to driving on a suspended license based on stipulation of your counsel. And there's a sufficient factual basis of no valid driver's license. And I find that you are alert and you are intelligent. As to both cases, the court will adjudicate you guilty. As to case number 2020 CT 2420, which is the driving on suspended license, I'll order 78 days in jail with credit for 78 days time served and court costs. As to 2020 CT 5207, I will order court costs only, no other sanctions. All monies must be paid within 365 days of your release from incarceration. I am ordering your release as to both cases, as well as I've already issued an ROR, release on recognizance, on the leaving the scene case. Do you have any questions?
No, Your Honor.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date.
Thank you very much, Your Honor.
Thank you, sir. Okay. I can't hear you.
I will let the attorney know that he's been released, and I did tell him to call as soon as he's released.
Who set the trial date? Then, yes, it will stay set. Okay. Chad Bargerstock. Previously bonded per jail staff. Rory Barnes.
Yes, ma'am.
All right, in your case, sir, I find probable cause for possession of cannabis less than 20 grams. Bond stays at $500. I find probable cause for resisting an officer without violence. Bond is set to $150. You do not qualify for the public defender, so I am not appointing the public defender to represent you in your case.
Okay, yes, ma'am.
Thank you, sir. Oh, you had a question?
No,
All right, thank you. Yes, no, question?
ma'am, I do, I'm so sorry. Is that it?
Yeah, yes, sir, that's it.
So I pay my bond, ma'am,
Yes, sir.
and I'm good to go?
If you can post your bond, yes, sir.
Yes, ma'am?
Yes, sir. You'll get paperwork for your next court date.
Okay, thank you.
Thank you, too. Sandra Cushman.
Yes, ma'am.
In your case, the court, this is a case where I didn't have a paperwork to find probable cause. Wait a minute, is this the one that you printed for me? No, that's a different person. I wasn't able to find probable cause because of lack of paperwork.
Your Honor, would you like to read my version?
Yes, please, thank
May I
you.
approach?
Yes, ma'am.
I'll just need to show it to counsel first.
Yes, that's fine.
Yes.
Thank you. Okay. Thank you. All right, ma'am, in your case, I do find probable cause for violation
Ma'am,
of, I'm sorry, can you hear me?
I'm sorry, I couldn't hear you.
Yeah, okay. In your case, I find probable cause for violation of an injunction, for violation of the actual injunction. And I am going to set a bond in this case at $500. I'm going to order you to have no contact.
Ma'am, I have nothing. I have no money. I have no resources. I have no phone numbers.
Let me finish my order.
Yes, ma'am.
So I don't get distracted. I'm going to order you to have no contact with the victim, not to return to the location where this incident occurred, possess no weapons or no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. You have another case of trespass after warning and violation of a domestic injunction. And I had made a note to myself that if I was able to find probable cause for the new case, then I was going to revoke the bond and set no bond on the old case because the charge is essentially the exact same charge.
Your Honor, the only argument defense would make is that my client was arrested, seen at first appearance, in August 6th, and to date, no information has been filed. It looks like it was referred back to the state.
If there's no information, then I won't take any action. What says the state?
Formal charges have not been filed, Your Honor.
All right, so I'm not going to take any action on the out on bond case because of that. However, the $500 bond stays, ma'am. I'm sorry if you don't have any resources. The public defender is appointed to represent you, and they can file a motion on your behalf to have a hearing on the reduction of the bond if they believe it's appropriate to do so. Thank you, ma'am.
Thank you.
Randy Freeman. Sir, in your case, the court finds probable cause for trespass on property.
And Your Honor, the offer from the state is an adjudication of guilt, credit time served, no return to 1020 West Canton Avenue in Winter Park, Florida. And Mr. Freeman would like to accept and enter a plea of no contest.
All right. So Mr. Freeman is entering a plea of no contest. And how much time served does he have?
2 days.
2 days. Mr. Freeman, is this your signature here at the bottom of this plea form? And did you read this document before you signed it? Do you understand that by entering a plea of no contest, you're giving up the rights on the front of this plea form? Are you under the influence of any alcohol or drugs or medicine? Do you understand that conviction will result in your deportation if you're not a U.S. citizen? All right, there's a sufficient factual basis. You are alert, you're intelligent, you're adjudicated guilty, you're sentenced to 2 days in jail with credit for 2 days' time served. You're ordered to not return to 1020 West Canton Avenue, Winter Park, Florida, and to pay mandatory court costs, which must be paid within 365 days of your release, and I am ordering your release as to this charge. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. All right. Brandy Lee. Brandy Lee. Is that Brandy Lee? Are you Brandy Lee?
I don't know who that is.
You have a booking number?
Your Honor, we have Reyes, Demetrius Reyes.
Okay, I don't know if there's a booking number on Brandy Lee,
She's not,
but that's who I have next.
Lee is not on our docket.
She was in my paperwork. Is there a booking number on here?
Inmate number 220-23814.
Where you get that from? Okay, if they said inmate number, I would have known.
She bonded, Your Honor.
Bonded? Okay. There, she previously bonded per jail staff, per probation staff. Demetrius Lewis Reyes? All right. In your case, the court finds probable cause for petty theft.
And Your Honor, the offer from the state is an adjudication of guilt, credit time served, and Mr. Reyes would like, in court costs, and Mr. Reyes would like to accept and enter a plea of no contest.
How much time, sir?
2 days.
Mr. Reyes, is this your signature here at the bottom of this plea form?
Yes, Your Honor.
Did you read the plea form before you signed it?
Yes, Your Honor.
Do you understand that by entering a plea of no contest, you're giving up the rights on the plea form?
Yes, Your Honor.
Are you under the influence of any alcohol or drugs or medicine?
No, Your Honor.
Do you understand that conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, Your Honor.
All right, there's a sufficient factual basis. You are alert, you're intelligent. I will adjudicate you guilty. Order 2 days in jail with credit for 2 days' time served, and order court costs. Court costs must be paid within 365 days of your release from incarceration, and I am ordering your release as to this charge. Do you have any questions?
Nope.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. You may exit. James Sorrell. Mr. Sorrell, in your case, I find probable cause for providing false ID to a law enforcement officer. Bond will stay set at $500. Thank you, sir. Deborah White. In your case, Ms. White, I find probable cause for the charge of open container.
And, Your Honor, the offer from the state is an adjudication of guilt, credit time served, and court costs, and Ms. White would like to accept and enter a plea of no contest.
All right, what's Ms. White's time served?
2 days.
Okay. Ms. White, ma'am, is this your signature here at the bottom of this plea form? And did you read this document, ma'am, before you signed it? Are you under the influence of any alcohol or drugs or medicine today? You understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? You understand that? All right, there's a sufficient factual basis in your case. You're alert, you're intelligent, and I'm adjudicating you guilty, ordering you to serve 2 days in jail with credit for 2 days' time served, and ordering you to pay court costs. Court costs must be paid within 365 days of your release, and I am ordering your release as to this charge. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Amy James.
Behavior, Your Honor.
All right, Amy James was picked up on a failure to appear, and there was a bond of 1,000. Are you waiving?
Yes, Your Honor.
All right, public defender waives. Charles Jenkins.
Yes, ma'am.
Mr. Jenkins, in your case, I find probable cause for count 1, possession of an open container. Bond will stay at $250. I find probable cause for count 2, state misdemeanors, and bond is set at $100.
Your Honor, in both cases, the state has made an offer of an adjudication, credit time served, and court costs. Mr. Jenkins would like to accept and enter a plea of no contest.
All right, how much time
2
served
days
does
time
Mr.
served.
Jenkins have?
2
5?
days.
2?
Yes.
All right, 2 days. Mr. Jenkins, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this document, sir, before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine today?
No, ma'am.
You understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, sir, there's a sufficient factual basis in your case, and you're alert and intelligent. You're adjudicated guilty as to both count 1 and count 2, and sentenced to serve 2 days in jail concurrent. Further, the court is ordering mandatory court costs to be paid within 365 days of your release from incarceration, and I am ordering your release as to this charge. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You may exit. Kalota Brown, you're picked up for failure to appear, and bond will stay set at $2,000.
And Your Honor, the offer from the state is an adjudication of guilt, credit time served. Ms. Brown, yes, Your Honor, would like to accept and enter a plea of no contest.
All right, and are you, since this was a failure to appear, I didn't read the charging affidavit, are you able to stipulate to a factual basis to the charge?
Yes, Your Honor.
Okay, thank you. Ms. Brown, ma'am, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read the plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
No, ma'am.
Do you understand a conviction on your case will subject you to deportation if you're not a U.S. citizen? All right, based on stipulation of counsel, I find there is a sufficient factual basis, and I find you to be alert and intelligent. What's her time served?
2 days.
You're adjudicated guilty. You're ordered to serve 2 days in jail with credit for the 2 days you have already served. You must also pay mandatory court costs in this case within 365 days of your release from incarceration, and I am going to order your release as to this charge. You have any questions, ma'am?
Yes, ma'am. How much is the court cost for this?
It will be included on your paperwork, ma'am. All right. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date.
Thank you.
Thank you, too. Shalib Tillman. Mr. Tillman, you were picked up for failure to appear.
Excuse me, Your Honor. He's posted his bond.
Oh, so this is not Mr. Tillman? This
Still
is,
been posted?
Yes, his bond is pending.
okay, so his bond is pending, all right. So the $200 bond has been pending. So it says here that he's transient, no address?
Yes, Your Honor.
Okay, and you have a job making $600 per week? Okay, well, because of that, you don't qualify for the public defender. But you do need to receive your paperwork and read it to know when your next court date is, so you don't fail to appear again. And hire a lawyer to represent you since you can't afford to hire one. Thank you.
Thank you.
Mackenzie Bennett,
Yes, ma'am.
in your case, the court finds probable cause for driving on a suspended license with knowledge, and bond stays at $500. The court is revoking the out of bond case for fleeing and eluding and sets a bond of no bond.
Your Honor, there was an offer to resolve the driving while license suspended.
I'm still doing no bond on and revoking a pretrial diversion on the other case.
Okay.
So he can resolve it if he wants, but I'm still doing no bond and I'm revoking because he was driving when he knew that his license was suspended.
Excuse me,
You have just a moment to explain that.
Does he still want to plea on the new case?
No, Your Honor,
Or I'll enter a not guilty plea? Probable cause is found, and again, as to the new case, bond is set at $500, and the court is ordering you to not drive without a valid driver's license. Revocation of the bond on the earlier case, and bond is set at no bond. It's actually revocation of pretrial release, pretrial diversion, and bond is set at no bond. Brianna Walker. Ms. Walker, you were picked up for failure to appear. Your bond will stay set at $1,000 for that charge.
Your Honor, the offer from the state was an adjudication of guilt, credit, time served. Ms. Walker would like to accept and enter a plea of no contest.
One day.
Are you able to,
Yes, Your Honor, defense will stipulate to a factual basis.
okay, one moment, one moment. What's the time served on this case?
One day.
All right, and I actually do have a sufficient factual basis as well. It was attached. Ms. Walker, is this your signature here at the bottom of this plea form? Did you read this plea form before you signed it? Yes or no? Are you under the influence of any alcohol or drugs and medicine at this time?
No.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes.
All right, there is a sufficient factual basis in your case. You're alert, you're intelligent, you're adjudicated guilty. You're ordered to serve 1 day in jail with credit for the day you have already served. And you must also pay mandatory court costs within 365 days of your release. I am ordering your release as to this charge. Do you have any questions?
No.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Reno Woods.
Yes, ma'am.
All right, in your case, the court finds probable cause for count 1, failure to register your motor vehicle, bond stays set at $1,000. Count 2, no valid driver's license, bond is set to $500. And count 3, no insurance, bond is set to $100.
And Your Honor, there was an offer to resolve all cases
Okay,
with a withhold of adjudication and credit time served. And Mr. Woods would like to accept and enter plea of no contest.
all right.
Your,
Yes, ma'am. One, okay, one at a time. No, they did it by count. So they put them, see, they put them in the same place.
it's not on my,
They,
can I get that case number, Your Honor? Because
case number 22 CT 5682AO and 22 CT 5683AO. Maybe one of them, the state choose not to charge. No motor vehicle registration was charged, and then no driver's license was charged, so maybe the no insurance was not. You don't have a citation for it? Oh, you didn't get the citation? Yeah, but I don't have a case number.
Right, and we won't have, we can't give them one until we get a citation, so they notify the officer to bring us a citation. So we give the case number later on, but we still.
How does the state want to handle that? Does the state want me to reset that count, or does the state want me to dismiss it?
Your Honor, if I heard correctly, it sounds as though the officer has been made aware and will be submitting the citation.
Maybe, perhaps, but does the state have any objection to me dismissing the third case? I do have probable cause for it. It's included in this PC, but he's pleading on the first two cases, so if you don't have an objection, I will dismiss it.
No objection, Your Honor.
All right. That's right. Yeah. Yeah, you guys, y'all got it? Yeah. Okay. So, what's his time, sir?
2 days.
Okay. Mr. Woods, in your case, I have two plea forms here, 2022 CT 5682 and 2022 CT 5683. The first case is failure to register your motor vehicle and no valid driver's license. Is this your signature at the bottom of these plea forms?
Yes, ma'am.
Did you read these plea forms before you signed them?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
No, ma'am.
Do you understand a conviction on these cases will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, there's a sufficient factual basis and you're alert and you're intelligent, and I will withhold adjudication of guilt as to both cases, order 2 days in jail to run concurrent on both cases, and order mandatory court costs on both cases. Court costs must be paid through the clerk of courts. Within 365 days of your release, I am ordering your release as to both cases. You have a third case, insurance violation, for which we do not have yet a citation number. I am ordering a dismissal of that case. The clerks are ordered to provide you with documentation that that case is dismissed once the officer submits the citation to them. Case is dismissed. Thank you, sir. Any questions? You have a right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Okay. Does anyone need a break? Does anyone need a break? Bathroom break or anything?
No, Your Honor.
Everybody's still good to keep going?
yes.
All right. Not everybody answered, but since nobody said they needed it.
I don't know if they need one. I don't.
Is there anyone who needs a break?
No.
Nothing from the state, Your Honor.
Okay, nobody needs. All right, thank you. Esmeralda Alvarado, in your case,
Your Honor, I had a PC challenge for the sale and delivery. I was gonna argue no PC.
Okay, that's in the second case?
Yes, Your Honor.
Okay, yes, ma'am. Okay, well, I'll go ahead and hear it. Go ahead. Go ahead.
Based on the four corners of the arrest affidavit, there is no indication that Ms. Alvarado sold or delivered any controlled substance to anyone, so I would ask that you find no PC.
Okay. State, any objection?
Your Honor, there is no PC for sale and delivery. However, there is for possession. I do believe it is a scrivener's error. If you look at everything else that is listed with regard to possession, it's 893.13 sub 6. Unfortunately, for this particular count, count 4, it was listed as sub 1 instead. So I believe it is a scrivener's error, Your Honor, and it is just supposed to be possession.
Okay, you believe it's supposed to be possession of a controlled substance. Was there any other controlled substance other than the cannabis, the Utalone, and the cocaine? Because I got those 3. And I have probable cause for all 3 of those. Was there a 4th controlled substance?
There is cocaine and methamphetamine, and there was also the ethylene, Your Honor.
Okay, I'm calling it Utalene. Let me tell you what I'm gonna do. I'm gonna agree with the state that that's likely a scrivener's error. And there was the meth. Now, this is what I had already done in this case. I found probable cause really for every single count. But I set bond on count 5 at $15,000. And all the other counts were set at 150 or either 100. If you still want to challenge count 4, then I can reset count 4, but I'm going to go ahead on and go through the other counts.
No challenge, Your Honor.
All right, as to count 1, bond is set at 150. Count 2, bond is set at 150. Count 3, bond is set at 150 with the state's, I did find probable cause for count 4, but I set bond at 150. I don't know that we need to do anything other than that. Count 6, bond is set at 150. Count 7, bond is set at 100. Count 8, bond is set at 100. Count 9, bond is set at 100. Count 10, bond is set at 100. And count 11, bond is set at 100. Oh, I'm sorry, I forgot to read the charges. All right, ma'am, I'm gonna read the charges so you'll know. Count 1 is possession of cannabis with intent to sell or delivery. Count 2 is possession of cannabis greater than 20 grams. Count 3 is possession of Utalone. Count 4 is sale or delivery of a controlled substance, which is likely the meth count. Count 5 is possession of cocaine with intent to sell or deliver. Count 6 is possession of cocaine. Count 7, 8, 9, and 10 are all counts for neglect of a child for each of 4 children. And count 11 is possession of paraphernalia. And I do find probable cause for each one of those counts, and I announced the bonds already. In the other case, robbery with a firearm, bond stays set at no bond. And count 2, battery, bond stays set at $1,000. You are ordered to have no contact with the victims and not return to the location where this incident occurred as a condition of release.
Your Honor, can I also ask for no contact with any co-defendants?
Yes, the court is further ordering no contact with any co-defendants. Any other or special orders that the state is asking the court to impose?
Your Honor, with regard to the second case, and I apologize, I don't have a case number with the neglect of a child. I'm sure that DCF was contacted, so if she could comply
Yes,
with any
ma'am.
DCF plan.
Yes, the court is ordering as a condition of release to comply with any DCF plan as to case. I want to make sure we get the right one. There's a lot of paperwork here. 2022 CF 11812 AO. Thank you. Jordan Brown. Mr. Brown, in your case, the court finds probable cause for driving on a suspended license with knowledge. Bond will stay set at $2,500. As to your out on bond case, I revoke the bond and set a bond of no bond on both count 1 and count 2. Public defenders appointed. Nestor Sestero. Mr. Sestero, the court finds probable cause for petty theft with 2 prior convictions, and bond is set at, or stays at $1,000. You're ordered as a condition of bond to not return to the location where this incident occurred and have no contact with the victim. Juan Fernandez Cruz. He was picked up for failure to appear, and I would be appointing the public defender.
Defense will waive, Your Honor.
All right, court will order the bond to stay set at no bond on both count 1 and count 2. Kiana Marie Flowers.
Bonded, Your Honor.
Previously bonded per the jail staff. Michael Flowers. He was picked up for failure to appear, and I would be appointing the public defender.
Defense will waive, Your Honor.
All right, bond will stay set at $5,000 on that case. Maurice Fox, Jaden Maurice Fox. All right, in your case, the court finds probable cause for aggravated assault with a firearm, and bond is set at $5,000. The court is revoking the bond on the out on bond case and setting bond at 0, revoking pretrial diversion as well. Bond is set at no bond.
Your Honor, with regard to the 22 CF 10952, no
Yes.
contact with the victim, no weapons, no firearms?
Oh, yes, ma'am, sorry. The court is also ordering no contact with the victim, no weapons, no firearms, surrender any weapons or firearms to law enforcement within 24 hours, and no return. Tiffany Gaudini. Tiffany Gaudin. Ms. Gaudin, in your case, the court finds probable cause for count 1, possession of an unauthorized driver's license. Bond stays at $2,500. Count 2, possession of methamphetamine. Bond is set to stays at $150. Count 3, trespassing in a structure or conveyance. Bond stays at $100. The court revokes the bond on your out on bond case 22 CF 28790, and bond is set at $10,000. And the court revokes bond on your out on bond case 2022 CF 11277 AO, and bond is set at $2,000. The court is ordering you to not return, on the new case, to not return to the location this incident occurred and have no contact with the victim. Luis Gonzalez. In your case, the court finds probable cause for petty theft with 2 prior convictions, and bond stays set at $3,500. You're ordered to have no contact with the victim and not return to the location where this incident occurred. Public defenders appointed.
Do you know where the incident took place?
Yes, sir.
At the Home Depot.
The Home Depot, sir.
Thank you.
All righty. Llewellyn Hines. In your case, the court finds probable cause for possession of cocaine, and bond stays set at $1,000. And the public defender is appointed. Robert Arthur Lewis. In his case, I do find probable cause, and I was appointing the public defender. Would you like to reset or waive?
Waive, Your Honor.
All right, his appearance is waived, and bond is stays set at $1,000. Court orders no return and no contact with the victim. Carlos Rafael Marrero Lozada. In your case, you were picked up for failure to appear, and bond will remain set at $2,000 in that case. Public defender is appointed. All right. Japrea Mitchell. Mitchell.
Yes, ma'am. She was behavior, Your Honor.
All right, in Ms. Mitchell's case, I am finding probable cause for her charge of possession of MDMA, and bond will stay at $1,000, and I was planning to appoint the public defender. Waive or reset?
Waive, Your Honor, I'm sorry.
All right, no, her appearance is waived, bond stays at $1,000. Okay, I think that takes care of what the bondman was concerned about. She's, Tommy Payne.
He bonded, Your Honor.
Previously bonded per jail staff. Michael Sparkman. Michael Sparkman.
I'm sorry, Your Honor. We have Soto, Sebastian Soto. after
Okay.
payment.
You have the booking number?
Michael Sparkman, I don't have any Soto.
2202-3792.
Don't have that at all.
I have Soto, but the one the judge was talking about,
Maybe in
I
the
was trying to
last
find
one.
that person.
Okay.
Sparkman was after Soto on our
Okay.
team.
No, I just don't have Soto at all. It was just not a part of my paperwork. Oh, did I? Okay, yes, I do have Soto. Sebastian Soto? All right. There's probable cause in your case of principal for first-degree robbery with the firearm, count 1, and principal for first-degree robbery with the firearm, count 2. Bond will stay set at no bond on both counts. The court is ordering you to have no contact with the victims, not return to any 7-Eleven store, and not associate with any co-defendants in this case. No bond. Michael Anthony Sparkman, all right, you're picked up for failure to appear in your case. Bond will stay set at no bond. Shanika Thomas, in your case, the court finds probable cause for grand theft, 3rd degree. Bond stays at $2,500. Probable cause for a retail theft, bond is set to $150, and probable cause for providing false ID to a law enforcement officer, bond is set to $100. The court is ordering you to have no contact with the victim and not return to the location where this incident occurred. Further, the court is ordering, that's it. Actually, let's have her come back. We'll bring her back. All right, ma'am, in your case, this case was, the bond was previously set by Judge Marquez, and she did not indicate a modification, so I'm gonna redo it, and bond will stay at $2,500 on count 1. Bond will stay at $1,000 on count 2 and $500 on count 3, since the judge who signed it did not indicate that there was, she agreed for me to modify it at first appearance. Otherwise, I would have modified it, but it's gonna stay as is, with no return to the scene and no contact with the victims. Paul Westfall?
He's Currently psych mental health, Your Honor.
All right, what says the public defender? Of course, I did appoint your office to represent him.
Defense will waive, Your Honor.
All right, his presence is waived, and the court will, court does find probable cause and orders a bond of $5,000 on count 1, 100 on count 2, 100 on count 3, 100 on count 4, and 150 on count 5. The court orders no return, no contact, possess no weapons and no firearms, surrender all weapons and firearms to law enforcement within 24 hours of release. Latasha Winkster,
Mental health, Your Honor.
mental health,
She also has, out on bond or open cases.
okay. All right, she has 3 VOPs, which are open, and it's showing RORs. Most people don't get ROR'd on a VOP, but, defense, as to the new case, are you planning to waive? I am appointing your office, or you want me to reset it?
I will waive, Your Honor. However, can I get the case number for the out on bond?
Okay, let me just go through the bonds on the new case. And so the court does find probable cause for all counts. Count 1, trafficking in methamphetamine, bond stays at $100,000. Count 2, possession of cannabis, bond is $150. Count 3, bond is $150. Count 4, bond is $150. Count 5, bond is $150, and count 6, bond is $150. As to the new cases, they are 2020 CF 6395AO, and it says it's an ROR on a VOP for a drug case. 2021 CF 887AO, another ROR on a VOP, and 2021 CF 14565AO, another VOP. It doesn't say whether it's an ROR or not, but I don't understand how these can be RORs if it's a VOP.
And they don't show up in the clerk of courts, it only shows up in the state attorney's office, and it just talks about how they're open cases with, status hearings coming up.
I need to look at these, I guess.
Or,
I'm sorry, she's mental health.
status hearing
I got mental health.
coming up, they're drug
Miss,
offenses.
Miss Eugene, can you look up 2020 CF 6395AO?
Yes, Your Honor.
And I just rarely see someone released on their recognizance on a VOP. That's just not something I usually see. But maybe it's because she's in a program, maybe?
Drug court?
It looks as though in July of 2021, she was given 3 years probation to complete the drug court program.
Oh, okay, so they probably did. All right, then I'm gonna order, revoke the ROR and set no bond. Revoke the ROR and set no bond on 2021 CF 887. I don't even know whether there was a release on the other case, 2021 CF 14565.
In 2022 CF 6395AO, is that one still showing open? I saw reclosed. I didn't see a new.
6395 AO?
Yes, Your Honor.
She was in the drug court program, apparently, in both the 2020 CF 6395 and the 2021 CF 887 case. I don't know if she's in, oh, and yes, also the other case as well. So I will, revoke release in that case as well, and in order no bond. All three cases, she was in drug court. Dwight Wright,
He refused, Your Honor.
public defender wish to waive?
Yes, Your Honor.
All right, in his case, the court finds probable cause for count 1, and bond stays at 1,000, and count 2, bond stays at 100. Any other cases?
No, Your Honor.
All right, court stands in recess.
Qualifies for pretrial.
Thank you, Ms. Keys. Mr. Brigg, in your case, the court does find probable cause for battery, domestic violence, and tampering with a witness to hinder communication. And for each count, I will order you to be released in a pretrial release program. You're required to comply with all of the requirements of pretrial release.
Your Honor,
Yes, ma'am.
I do apologize for interrupting. If the state could be heard, Mr. Briggs has 3 previous domestic violence incidents, one from 2019, 15, and 13. The 2019 was dropped. However, the 2015 and the 2013, one was an adjudication, one was a withhold, and these are 3 different victims, Your Honor.
Are you therefore objecting to the pretrial release?
At this time, I am, Your Honor.
All right, based upon the state's additional information being provided to the court and the state's objection, the court will not authorize release in the PTR program. At this time, the court will instead order a bond on count 1 of $500 and count 2, $1,000. The court is ordering no contact with the victims, no return, with the exception of a one-time visit in the presence of law enforcement to recover personal belongings, possess no weapons and no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release. Any other conditions that the state wishes the court to consider imposing?
No, Your Honor.
Thank you, sir. Just for the record, the public defender will be appointed on all cases unless otherwise noted. Unless otherwise noted. So we have is this a private attorney here? Okay, and what about the other one? Are any of them on the video? No. They're all, okay, okay, all right. Maurice Cotton. Sir, the court finds probable cause in your case for tampering with a witness and sets a bond of $500 and battery domestic violence, and I also set a bond of $500 as to that count. Sir, the court is ordering as a condition of bond that you have no contact with the victims, that you possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Further, that you not return with the exception of a one-time visit in the presence of law enforcement to recover personal belongings. Further, sir, you were picked up for an on-view violation of probation, for which bond will stay set at no bond.
Your Honor, DCF was contacted regarding the new case. If he could comply with any DCF plan?
The court will also order, as a condition of a release, compliance with any DCF issued plan.
It doesn't matter. He's saying his victim is out there, I just don't know.
Comply with any DCF issued plan. I'm sorry, Ms. George, what did you say?
Oh, they said they're not. He was saying, he thought his victim was out there, Your Honor, but they're saying no.
Oh, okay. All right, thank you. All right, next case, Salvatore Anthony DiConstanzo. Salvatore DiConstanzo. Mr. DiConstanzo, sir, in your case, the court finds probable cause for aggravated battery and sets a bond of $3,500. Further, I am ordering you to have no contact with the victim, possess no weapons and no firearms, and surrender all weapons and firearms in your possession to law enforcement within 24 hours of your release. You do not qualify for the public defender, so I am not appointing the public defender at this time. Oh, also, sir, I'm ordering no return, with the exception of a one-time visit in the presence of law enforcement to recover any personal belongings or effects. Anything further from the state?
DCF again was contacted, Your Honor.
All right, the court is further ordering that you comply with any DCF plan as a result of this case. Thank you. Dimitri Kendrick Duarte.
And he qualifies, Your Honor.
Yes, ma'am.
All right. Mr. Duarte.
Yes, ma'am.
Sir, the court finds probable cause for your charge of battery, domestic violence, and sets a bond of $500, and for grand theft, and sets a bond of $1,000. You do qualify for the pretrial release program. Actually, so you know what, I'm gonna change that, and I'm gonna order you to be released in the pretrial release program. You must comply with all the conditions of pretrial release. I am also ordering you to have no contact with the victim, not return, with the exception of a one-time visit in the presence of law enforcement, possess no weapons and no firearms, and surrender any weapons or firearms in your presence
Yes, ma'am.
to law enforcement, in your possession to law enforcement within 24 hours of release. All right. Ernesto Lara.
Your Honor,
Yes.
Laura is currently on mental health checkup.
Okay, mental health per the jail staff. Should I reset this, or does the public defender wish to waive this appearance since I am appointing the public defender?
Wait, Your Honor.
All right, the court did find probable cause in this case. Bond is set at $3,500. No hostile, no contact, no return, with the exception of a one-time visit with law enforcement. Possess no weapons or firearms, and surrender weapons or firearms to law enforcement within 24 hours of release.
Your Honor.
Yes.
Also, the next one, Richard Rivera, he's also on psych mental health.
Okay, Richard Rivera, jail staff has also indicated some concerns, and he's not able to be here today. I do find probable cause in this case, and I am appointing the public defender. Do you wish to waive his presence?
Yes, Your Honor.
All right, as to count one, the court orders a bond of $3,500. As to count two, $500. No contact with the victim or the victim's family, no return. No contact with any minors under the age of 18. Possess no weapons, no firearms, and surrender all weapons or firearms in his possession to law enforcement within 24 hours of release. I don't think he resided there, but in the event there were personal belongings, a one-time visit is authorized in the presence of law enforcement to recover personal effects. Was there DCF involvement?
Yes, Your Honor.
And the defendant must also comply with any DCF plan related to this case. I ordered DCF compliance, Madam Clerk, in case you didn't catch that. Brittany Bishop.
Excuse me, Your Honor, she qualifies for pretrial.
I'm sorry, who's speaking? Someone,
She qualifies for pretrial.
you're gonna have to talk a little louder. Ms. Bishop, you qualify for pretrial release, and I am finding probable cause in your case for the charge of battery, domestic violence, and ordering you to be released in the pretrial release program. There's a witness, so we'll go ahead and swear the witness in and see what the witness has to say.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Lance Bishop.
Mr. Bishop, either the state or defense or both may have questions of you. Please answer clearly into the microphone so I don't have to ask you to repeat yourself. Into the microphone, please.
Yes, ma'am. Can you hear me?
Sort of. Can you hear me?
Yes, ma'am.
All right, well, I want to be able to hear you the exact same way you can hear me.
Can you hear me now?
Yes, very well.
Perfect.
Thank you.
Good morning, sir. To the left, to the, how do you know the defendant?
She's my wife?
Do you live together?
Yes, ma'am.
While this case is pending, would you like to have contact with her?
Yes, ma'am.
Has something like this happened before?
No, ma'am.
Were drugs or alcohol involved in this incident?
No, ma'am.
I have no further questions, Your Honor.
Thank you, defense.
No questions, Your Honor.
All right, I'm releasing the defendant on a pretrial release program with no hostile contact with the victim, possess no weapons and no firearms, and surrender all weapons or firearms in your possession to law enforcement within 24 hours of release. And actually, she does not qualify for the public defender, so I am not appointing the public defender in this case.
You have to hire an attorney.
You just stood in for IAs, but she doesn't qualify.
Okay, thank you.
Jose Fernandez.
Good evening, ma'am.
Good morning. Sir, in your case, the court finds probable cause for battery, count 1, and for resisting an officer, count 2. Bond is set at $500 on each count. It indicates here that you do not qualify for the public defender, so I am not appointing the public defender. I am revoking the bond on your out on bond case based on your charge here, and doubling the bond or tripling it to $1,500. You're ordered to have no contact with the victims as a result of this bond, possess no weapons, no firearms, surrender all weapons or firearms in your possession to law enforcement within 24 hours of release, no return with the exception of one time in the presence of law enforcement to recover personal belongings. Thank you, sir.
And thank you, Your Honor.
Casey Greco.
Your Honor, Casey is also, Greco is also psych out to mental health right now at this time?
All right, in Greco's case, I have found probable cause and the public defender will be appointed. Do you wish to waive or reset?
Waive, Your Honor.
All right, presence is waived. The court finds probable cause. Bond is set at $500. No contact, no return with the exception of one time in the presence of law enforcement to retrieve personal belongings, possess no weapons and no firearms, and surrender weapons and firearms to law enforcement within 24 hours of release. Leviticus Antoine Henderson.
Present.
Mr. Henderson, in your case, the court finds probable cause for battery. And I will order, yes, ma'am.
Witnesses.
Oh, there's a witness approaching. Raise your right hand to be sworn in. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
What is your name?
Ebony Henderson.
All right, Ms. Henderson, I need you to answer any questions that are asked of you in that microphone, and I need to be able to hear you the first time, so I don't have to ask you to repeat yourself, okay?
Yes.
All right, can you answer questions into the microphone, ma'am?
Yes, ma'am.
All right, thank you.
Good morning, ma'am.
Good morning.
How do you know the defendant?
He's my husband.
Do you live together?
Yes.
While this case is pending, would you like to have contact with him?
No contact.
Okay. Has something like this happened before?
Yes.
Were drugs or alcohol involved in this incident?
No.
I have no further questions. Thank you.
Defense?
No questions, Your Honor.
All right, I'll order a bond of $500, no contact with the victim, no return with the exception of one-time visit in the presence of law enforcement to recover personal belongings, possess no weapons and no firearms, and surrender all weapons and firearms in your possession to law enforcement within 24 hours of your release. Thank you, sir. Sean Hunter. Mr. Hunter, in your case, the court finds probable cause for the charge of battery, domestic violence, and sets a bond.
Your Honor, he qualifies for pretrial release.
Okay, you qualify for pretrial release, so I will order you to be released pretrial, as well as you must comply with all of the conditions of pretrial.
Your Honor, I apologize again. It seems as though there was a prior incident with the same victim in February of this year.
Was there a charge that resulted in that?
Yes, Your Honor.
Okay, was there a conviction, or was there a declination, or can you tell me any more information?
One moment, Your Honor.
Okay.
The case was no-billed in March.
All right. I'll allow the defendant to participate in a pretrial release program. Sir, you must follow all the requirements of pretrial release. You must have no contact with the victim, not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal belongings, possess no weapons and no firearms, and surrender all weapons and firearms in your possession to law enforcement within 24 hours of your release. Thank you, sir.
Your Honor, did you appoint the public offender?
One moment. Yes, ma'am. Yes, I did. Ma'am,
Did you appoint the public offender, Your Honor?
I did. Yes, ma'am.
And DCF was also contacted, Your Honor.
Okay. Madam Clerk, I'm going to add a condition, and that is to comply with any DCF plan that may be issued in this case. Demian Matthew.
Yes, ma'am.
Sir, the court in your case finds probable cause for the charge of battery. Is there a witness? Yes or no?
Yes, Your Honor.
Okay. Ma'am, raise your right hand to be sworn in. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Ma'am, I need you to answer any questions into that microphone. I can hear you real good, so keep talking just like you're talking, okay?
Okay.
State, you may inquire.
Has she been sworn in? Did I know?
I just did it, I swore.
I do apologize.
That's okay.
Good morning, ma'am.
Good morning.
How do you know the defendant?
He's my boyfriend.
Do you live together?
Yes.
While this case is pending, would you like to have contact with him?
Yes.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
No.
I have no further questions. Thank you, Your Honor.
Defense?
No questions, Your Honor.
All right. Sir, I am ordering a bond of $500. I am ordering you to have no hostile contact with the victim, that you possess no weapons and no firearms, and surrender all weapons and firearms in your possession to law enforcement within 24 hours of release. Thank you, sir.
Thank you.
Anthony Mazzi.
Your Honor,
Okay,
he
thank
qualifies
you.
for pretrial.
He qualifies? Okay, Ms. Keys, I'm starting to hear you now. That's
Morning,
good.
Judge. For the record, Attorney J. Ruth, behalf of Anthony Mazzi. He does live in Citrus County. We'd asked for a straight bond. I spoke with the state. They've agreed to a $500 bond. We do have the alleged victim, Sydney, present.
All right, okay. Do you want us to inquire of the victim as
That'd be
well?
great, Judge. Thank you.
Ma'am, raise your right hand to be sworn in. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, ma'am, keep talking in the microphone the exact way you just did. The state or defense both may have questions of you.
Good morning, ma'am. You can put your hand down. How do you know the defendant?
He's my boyfriend.
Do you live together?
Yes.
While this case is pending, would you like to have contact with him?
Yes.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
No.
Neither one?
Possibly alcohol.
Okay. I have no further questions. Thank you.
Mr. Ruth?
Nothing additional, Judge. I think that covers it.
All right. Ms. Keys, if I put him on the PTR program, will you be able to monitor him from Citrus County, or would that be difficult?
He can be monitored. He just has to physically come and check in Orange County.
Okay, so he would have to drive all the way from Citrus County? You all don't have like an office up in, all throughout the state? All right, he resides in Citrus County. Based on that, I will order a bond of $500, order you to have no hostile contact with the victim. $500 possess no weapons and firearms, and surrender any weapons or firearms in your possession to law enforcement within 24 hours of release. The public defender is not appointed on this case. Obviously, he's represented by private counsel.
Thank you, Judge. Have a great day. Good to see you.
Thank you. Good to see you. Christian Oropesa. Christian Oropesa, sir, in your case, the court does find probable cause for the charge of battery, domestic violence. And I am setting a bond of $500. Counsel, state your name for the record.
Christian Oropesa.
Okay.
For the record, Ken Yule on behalf of Christian Oropesa.
Yes, sir. And the court is setting a bond. He has 2 out on bond cases that the court will be revoking the bond on.
Your Honor, with regard to those cases, we'd like a chance to be heard if possible.
Go ahead.
So we have a couple of things going on. We have talked to the victims in the cases, and we did a declination of prosecution filed, both in the Osceola cases and also the Orange County cases, filed this morning around 8:15. They submitted them last night. Additionally, I do believe that with regard to Mr. Oropesa's history, there is no previous history of any kind whatsoever. I don't believe he's ever had any kind of conviction or anything of that nature. Mr. Oropesa is a healthcare provider. He works with the Davenport Dentistry. He has 4 kids, full provider, and he will be able to keep his job if he's released from custody. Again, there is no history other than these 2 isolated acts with 2 victims that do not want to press charges, and declinations have been filed in both cases. This was a lot easier back in the day in terms of if somebody picked up a new case, because the standard was put somebody maybe on GPS monitor or something of that nature. We don't do that anymore in Orange County. Back when I did IAs like 11 years ago, that was the standard thing if somebody picked up a new case. But my suggestion is the basic thrust of the legislature is to still look to see if the person would be a danger to the community, whether there's conditions of release that can satisfy him showing up for court, things of that nature. Based on the fact that, Mr. Oropesa's record, the fact that he has significant ties to Orlando, and based on the fact that you have 2 victims that truly don't want these cases to move forward, I do think that maybe revoking and then doubling the bond amounts would be appropriate in this case.
What's Ace Estate?
I could only find the felony case, Your Honor. I'm still looking for the misdemeanor to see if it's 2 separate victims. As Mr. Yulo is aware, even though there is a declination, that does not mean that the state cannot go forward. That's just one other aspect of it. I do see that the felony, that was an arrest from September 28th, Your Honor. So it's been less than 2 weeks since the previous incident, and he does have a conviction for possession of cocaine in 2016.
Okay. And so the felony was September 28th?
Yes, Your Honor, that's the
All
arrest.
right. All right. At this time, the court is setting a bond of $500 on the new law violation. I am revoking the bond on both the misdemeanor and the felony. I'm going to set no bond because I do find that there is a consequence of the defendant being a danger to the public. I don't have the victims here who are declining to prosecute. I don't have any data other than the state's information that case was just a few weeks before this case, and I am concerned enough to revoke the bond and set up a no bond status. Obviously, you can set a hearing before the assigned judges, and I would suggest have those witnesses present if they truly want to decline prosecution.
I would ask this, Your Honor, if and again, it's one of those things where, judgment call in terms of people's work schedule and things of that nature. If Your Honor has afternoon court, I do believe that we could arrange to have both of the victims here.
No, sir, I'm not going to be able to do that. I have court, but I have a schedule, and we want to stick to the schedule. You're going to have to set it in the division unless the state agrees, and I don't think I heard the state agree to what you suggested. I'm revoking the bond, and the bond will be set at no bond. State, just clarify to me that you prefer revoking the bond and setting no bond versus doubling the bond.
I do prefer to revoke, Your Honor.
All right, I'm going to follow the states on this one, particularly because of the proximity of the charges as well as the fact that there is no documentation or proof that the victims are truly understanding what it means to decline prosecution. Also, at this time, that's the court's ruling. Bond is set at $500, no contact with the victim in this case, no return with the exception of a one-time visit in the presence of law enforcement to recover personal belongings, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release.
Thank you, Your Honor. Thank you for your time.
Thank you. Michael Rigimball.
Yes, ma'am, Your Honor, he's also, mental health right now, currently on psych-op status.
All right, in his case, I have found probable cause, and I will be appointing the public defender. Do you wish to waive or reset?
Waive, Your Honor.
Right, his presence is waived. He qualifies for pretrial release. You wish for me to put him on a pretrial release?
Yes, Your Honor, he has.
And the court will order pretrial release. Comply with all conditions of pretrial release, as well as no contact with the victim, no return with the exception of one-time visit in the presence of law enforcement, possess no weapons or firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Janae Simon. The court finds probable cause in your case for battery, domestic violence. And I am setting a bond of $500, ordering you to have no contact with the victim, no return, with the exception of a one-time visit in the presence of law enforcement to recover personal items. Further, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you. Aaron James Gay.
TOT, Your Honor, to the,
I'm sorry?
TOT to Brevard County?
Oh, Brevard already picked him up? Okay, he's been previously picked up by Brevard County. Mateo Reyna Perlaza.
Bonded, Your Honor.
Bonded per the jail staff. Timbrel Battle.
Behavior, Your Honor, mental health.
Okay. In his case, it was a VOP for which I would be appointing the public defender. Would you like to waive or reset?
Waive, Your Honor.
His presence is waived. Bond will stay set or no bond on the VOP. Antonio Harrison. Mr. Harrison, let's see, you're picked up for on-view violation of probation, and bond will stay set at no bond. Public defender is appointed, yes, ma'am. Stephen Kelly.
Yes, ma'am.
Sir, you were picked up for an on-view violation of probation, for which bond will stay set at no bond, and in your misdemeanor case, the court will set, oh, that bond was already set, sorry, on view. I can scratch that. Thank you, sir. Jawan Leggett. All right, in your case, you're picked up for an on-view violation of probation for which bond is set at no bond, and probable cause for the new law, aggravated battery with a firearm and possession of a firearm or ammunition by a convicted felon.
Your Honor, there appears to be a witness.
Oh, yes. Ma'am, raise your right hand to be sworn in. Do you swear that the testimony you're about to give is true, the whole truth and nothing but the truth, so help you God?
Yes.
All right, thank you, ma'am. You may have questions from either state or defense. Please continue to speak as loudly as you can in that microphone, just like you just did before.
Okay. Your Honor, I believe that this is a witness, so at this time, the state does not have any questions.
All right. Does the defense have any questions?
No, Your Honor.
What is your name?
Samantha Rodriguez.
Samantha Rodriguez. All right, Ms. Rodriguez, neither the state nor the defense is choosing to ask you any questions in this case. I don't have any questions of you either. Was there something in particular that you wanted to relate to me? Is that why you came?
Yes, I came to support, he's my boyfriend.
Okay.
He supports me and our child.
Okay.
I understand that he has a history of some charges. So
Mhm.
if anything can be done in order for him to be released, and he does have a job, he's going to school. He provides, like I said, for our family, so if anything could be done.
Okay, you say he has a job and he's going to school?
Yes, he has a stable job and he's going to school
Mhm.
for a mechanic
Okay.
institute, and also he works at a mechanic shop.
Mhm.
So, like I said, if anything could be done in order for him to just keep providing.
Is his child your child, or? Okay.
Yes, he's the stepfather.
Okay, all right. It's just one child?
Yes, just one.
Okay.
And I am pregnant right now also, that's why I'm really like, you know.
Okay, and so there's one child and a child on the way.
Yes.
Did you want to say anything else?
I don't think I have anything else to say.
Okay, so State, do you have a recommendation as to bond as to count one?
Your Honor, defendant is accused of shooting someone in the back after a drug deal. So at least 15,000?
Well, yeah, at least.
Correct.
Your Honor, but he also has 2 violations of probation that's holding him at no bond.
They were not presented to me, so they may be coming later.
I believe they should have been, Your Honor.
Oh, from Polk County?
I know one is out of county. And
Oh, yes, yes, I was going to let him know that he has an out-of-county. I didn't realize it was a VOP, but yes, it is from Polk County, that is a VOP. But I'm only aware, there are 2 counts, so, yes, ma'am, you're correct. So, Ms. Rodriguez, the state and the court, we're troubled by the nature of the charge. There's going to be a bond in this case, but it's going to be a significant bond. As a matter of fact, I mean, the state said at least 15,000 before the court even came in here. The court was thinking of a bond of 25,000. This was a very serious case. These kind of cases, they're difficult because there's always a loved one like yourself who wants to see more leniency, and also maybe you have something going on like your pregnancy and your child and you need the extra support. So he's going to have to post a bond. As to count 1, I do find probable cause of 25,000, and as to count 2, a bond of 4,000. Conditions of bond are to have no contact with the victims, no return, possess no weapons or firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. There's an out-of-county warrant for a violation of probation, and bond has already been set at no bond for that, and bond is going to stay at no bond for that. And so he's not going to be able to post the bond in the new law violation because of the out-of-county violation. But I only show 1 out-of-county. It does seem to have 2 counts. There's something else that you were aware of, State, other than that one from Polk County?
There are armed views.
Was there another one?
There are armed views for Orange County and.
There's an Orange County one? Okay, let me just look through my paper. Oh, it's the on-site? Okay, and then there's also the on-view violation of probation in Orange County. Y'all gonna have to forgive me, it was right here, right in front of my face. I don't know how I didn't see it. But yes, there's the on-site violation of probation, and bond is at no bond on that. So, ma'am, he won't be able to bond out. He has no bond. He has lawyers that have been appointed to represent him, and they can assist him with attempts to secure bonds on those violations of probation. But best to you, ma'am, as you try to figure out what you're going to do while he's incarcerated.
Okay.
Thank you, ma'am.
Thank you.
All right. These are for the morning? All right, so who's going to call out the case numbers? instead of me?
I can do that, Your Honor.
Okay, thank you. Somebody help me. I don't have but so much vocal cords. Go ahead.
The first one that I have, Your Honor, is Israelis Anthony Pagan, 22 CF 10408. That should be denied and information was filed. Do you have them in alphabetical order?
What order do we have them in? Do we have Pagan? Maybe we can just let the clerk do it. Madam Clerk? Madam Clerk? Go ahead, Madam Clerk. As to Pagan, the state is moving to deny?
Yes, Your Honor.
That's denied. I did Pagan. The rest of them are in alphabetical order.
So you have Cody Russell Brolick,
Yes, ma'am.
22CF9956AO.
Granted, notice of non-filing.
Granted.
22CF7476 for Angel Claudio Canales.
Granted, notice of non-filing.
That's granted.
22CF10501AO for Nathaniel Crawford.
Granted, case was no billed.
Okay, that's granted.
22CF8400AO for Dylan Daly.
Denied, information was filed.
That will be denied.
22CF10512AO for Tershawn Rembert.
Dylan Daly had 3 cases, so.
I'm sorry. 22CF8403AO, Dylan Daly.
Denied, information was filed.
That one will be denied.
22CF8402.
Denied, information was filed.
Okay, that's denied.
And 22CF8652.
Granted, case was no billed.
Oh, that one's granted.
22CF10512, Tershawn Rembert.
Granted, notice of non-filing.
That's granted.
22CF10511 for Robert Ross.
Denied, information was filed.
That's denied.
22CF10450 for Osman Soreto Verino.
Denied, information was filed.
And that is denied.
22CF8419 for Warren Sweet.
Granted, notice of non-filing.
And that is granted.
Your Honor, the state has nothing else. May I be excused?
One moment, just one moment. I want to consult with everyone about what time I'm going to start up, since the court has already done all the reading for the entire day. So just give me one moment.